This video is a project of the Annenberg Foundation Trust at Sunnylands.
On September 27, 1957, President Eisenhower sent 1,000 men of the United States Army to carry out the law. The Supreme Court of the United States had said, the entire strength of the nation may be used to enforce, in any part of the land, the security of all rights entrusted by the Constitution. And that included my rights and the rights of 8 other Negro Americans who wanted to go to Central High School in Little Rock, Arkansas.
Does any of you know the name of the attorney who argued for the students in Brown versus Board of Education? Thurgood Marshall. Why would the 3 of us here have known Thurgood Marshall, do you know?
He was the first African-American Supreme Court justice.
He was on the Supreme Court. He was our colleague.
And he was here when I came to the court. Thurgood Marshall grew up in Baltimore, Maryland, and he went to school there. And when he wanted to go to law school, he applied to the University of Maryland, and he was turned down. Do you know why? Because he was African American. No, we won't take you in this law school. Isn't that amazing? So he came down to Washington, D.C., and he went to the law school called Howard, which was developed to take African American students and law students. And that's where he got his law degree. And they had it in an old house, and they didn't have a library. They met up in the attic of the old house. The students did, to get books and study. And Thurgood Marshall used to talk about ways that when they got out of law school, they could help the people of his race to improve their lives. And that's what he dedicated his life to doing.
And he had tried lots of cases in the South in the trial level with juries, not just up here, and had to go into the town on one route in one car and then leave another because it was dangerous what he was doing. But they made a movie out of Thurgood's life, and they showed all the investigations. They showed his trials, and they showed the background of Brown versus Board of Education, and the title was Separate but Equal. Is there anything about my description of the movie that makes you stop and think you might have suggested a change?
That separate wasn't actually equal?
Well, that's exactly the point. What about this doctrine of separate but equal? I mean, separate but equal is a good thing, isn't it?
Yes, but separate is inherently unequal, because once you separate 2 groups based on a certain characteristic, a psychological barrier arises that makes another group, the group that's separated, feel inferior. It's a badge of inferiority that arises.
Oh, but suppose there's 2 schools, one black, one white, and 2 high schools. Let's make them high schools. Small city, just 2 high schools, one black. But the black school has swimming pools and gyms and wonderful teachers and TV monitors and beautiful. It's a better school from all the physical facility. What's wrong with that?
Well, it doesn't matter which 2 groups you're separating. It's wrong to separate 2 groups.
Why is it?
Because
Wrong?
it makes the other
Why
group
is it
feel
wrong?
bad. It's morally wrong to separate 2 groups.
Why is it morally wrong?
It makes people feel bad.
It hurts them.
Separate but equal was the argument for the people who wanted to be able to maintain separate schools based on race. And that was what Justice Marshall and the other lawyers who were opposed to it were arguing against. And what's the provision in the Constitution that the court looks to in answering these questions?
In the Constitution, the 14th Amendment says that nor deny any person within jurisdiction the equal protection of the laws.
Well, what do you think? They had 2 sets of schools in the South. They had 2 sets of drinking fountains. They had 2 sets of railroad stations in the South. They had 2 sets of everything. One was called white and one was called colored. Normally, that was what they had. Okay, in your opinion, does that violate that provision of the Constitution? How many think yes? Okay, how many think no? Okay? Let's take anyone who says yes and explain to me why.
I think it's wrong because the basis of the separation stems from discrimination, and the whole reason that they're separated is from discrimination, and knowing that they will feel inferior.
People might have thought this is a system designed to make black people feel worse. Now, why do we want to do that? Well, maybe we want control, and maybe that way we can maintain more control over our society, and we don't have to give those people who are the descendants of the former slaves a chance. And my question is, why, if this is all so clear to us, which I think it is fairly clear, why did it take all that time before the court did anything?
I believe that it took 50, 60 years for this case to be pushed through because of Plessy versus Ferguson.
Exactly. There was an earlier case, wasn't there, called Plessy versus Ferguson.
Was Plessy versus Ferguson right when it was decided?
At that time it was, because that was kind of the mentality of the country, but
That didn't make it right, though, under the Constitution, did it?
no.
If you were writing the opinion to reverse Plessy versus Ferguson, you have to give the reasons. Would you say that society has changed?
I would say that society had changed because the recognition of Plessy as black because of the percentage he was had changed by that time.
But doesn't that indicate that Plessy might have been okay when it was, Plessy is 1896. That means it was probably a closer call in 1896 than in 1954.
It was never correct, but it was the decision that the court made at the time.
Well, I see some of the problem you're having. You want to be respectful. You say it's correct, it's the law of the land. What we're asking is, was it properly reasoned? Was the result correct under the Constitution? And sure, just because we say it, that I suppose it is the law for a while, but we can still ask if it's correct, and you indicate no. And I take it that's because, why? Why was it wrong in 1896?
It was wrong in 1896 because at the same time, racial discrimination was still wrong at that time.
There was still a hurt, there was still a moral wrong that your colleague said, it's still something that was just wrong as a matter of morals because we're hurting other people, even then.
Well, of course, do you think that the Supreme Court decides legal questions like the meaning of the Constitution based on whether the justices think it's moral or logical, or do they have to look at the language of the Constitution to make the decision?
They would have to look at the language of the Constitution in the 14th Amendment, where it says it cannot deny any person within its jurisdiction equal protection of the law.
Yes, and so what does equal protection of the law mean? The argument then that was accepted in Plessy was that if you have a separate school for white students and a separate one for blacks, but they're both equal, it's all right, it doesn't violate that section of the Constitution. So what's the legal argument, do you suppose?
The argument in Brown versus Board of Education was that separate schools, while they could be equal in all of the tangible factors that could be measured, were unequal in the intangible factors.
A sense of inferiority that affects their hearts and minds in a way never to be undone. Let me ask you this. Segregated schools existed in the public sector all across the South. In some states in the north, Kansas, Topeka was the Brown versus Board of Education, Delaware. And society was used to it in the sense that that's what they had, that's where the financing was, that's the way it was all organized. If you were Thurgood Marshall and you thought this was wrong under the Constitution, how would you begin to attack the doctrine of separate but equal? Do you know what he did? Do you know what their strategy was? Would you attack it first at the university level or at the grammar school level? Where would you attack it first?
Thurgood Marshall and the NAACP first attacked it at the university level.
Why did they do that?
because they could establish a precedent. I forget the court case.
Well, Sweat versus Painter.
Sweat versus Painter. That's where they established that in a law school, if a student was treated differently, he wouldn't receive the same education and the same benefits.
Yeah, they had cases in law schools where the student was admitted to the law school, but he had a study table in the library, and it was his own table, and was surrounded by a little cardboard thing to separate him. And as you say, it was just easier to show that this kind of separation was inherently unequal, and that was their strategy.
But think of that part of the Constitution. So here we have, on the one hand, they're not being treated properly because of race. And on the other hand, we have this part of the Constitution says you have to treat people equally. So you're looking at that, and you think, how can we get that changed? Well, who are the people who could change it?
The people who could change that is the people.
That's one group. You could get them to vote to change it. Now, there's a problem with that. There are two problems. What do you think the problem with that was? Big problem.
The majority was against that.
The majority was against it. And by the way, what group of people would have been most for it?
Minorities.
Right. And what about their voting?
They were not counted.
No, they weren't allowed to vote either, just in case. So we have like a safeguard
that
here.
was a big
okay, so
problem,
it looked
wasn't it?
pretty bad to go to the public here because, for one thing, the people most affected, they tried to stop them from voting, and very often successfully. And on the other hand, maybe they would have lost anyway because they were in the minority. So we don't know how the election would have come out, or are there some other people who might change that?
So what else could they have done?
Who could have said this equal protection clause is one thing, and this isn't right?
The Supreme Court.
So obviously we're looking for something else.
The Supreme Court could do it, and that's where they went.
All right, so now you have to use your imagination. And just use your imagination and think back in 1953, 54. We weren't there then, but there were 9 people. And some of them were clearly for Thurgood Marshall. But some were hesitant. Now, if they were in their room, there's a room back over here, and they would sit around and discuss this if the case is in front of them. So now here's what Thurgood Marshall have to do, what you should do. Imagine what they're saying. Imagine the people who are hesitant. What would they say?
Don't you think they might say, well, that's already been decided? Don't come to us. We decided that back in the 1800s.
Okay. So we decided that already. And they would have referred to what case?
Oh, Plessy versus
Exactly. So some could have thought that. But then, now you're Thurgood Marshall. So you're thinking, how am I going to stop them from saying that? And how is he going to do it?
Okay, in Plessy versus Ferguson, they argued that separate but equal is correct because even though it's separate, they have equal accommodations.
Right.
But Thurgood Marshall argued that even though accommodations can be equal, it's inherently wrong because of inferiority.
Right, that's an argument. Yeah. You have a very good argument that Plessy versus Ferguson is wrong. But it's decided. So why should we go back? There is the problem Thurgood Marshall is facing, and so how does he attack that?
What did he say and what did he argue?
He made the argument you just made. That's certainly one of the things he did. Yeah, and where else, what did he do? You also said what he did first. Where did he go? To the law schools. Now, if he won the law school case, because they all understood the law school. The judges all understand this is a very unfair way to run a law school. You can't get an education in a law school while you're sitting by yourself with a lamp somewhere. Now, he won that case. Now we go back and someone says to you, you're the lawyer, oh, we decided this a long time ago. And what do you say? Hey, judge, you said you decided Plessy v. Ferguson a long time ago, and it's decided this case. But just recently you decided a law school case, and you held the opposite. So now you don't have all the law against me. You have some law against me and some law for me. See, that's a pretty good way to argue a case. So he got what was happening was the law was changing. He proved to the judges that the law is changing. Therefore, they can't just go back and rely on that old case. They have to think. All right, now we got them thinking at least. That's a plus. And then you've come in with your moral argument and what practical is happening. Very good. Now, one more problem. Think of the people in that room, and there are some what you might call nervous Nellies. And these nervous Nellies are going to say what? They say, I see you're right. I see you're right. I'm so sorry that we have this horrible case of Plessy versus Ferguson. And I even see how we could get rid of it because we've now decided things opposite ways and we could do it. But I'm still really worried about something. What am I worried about? What is nervous Nellie worried about?
Because the public opinion is against.
And why should that make Judge Nervous Nellie worried?
Because the judge isn't elected, is he?
He's got his job. They send him his paycheck, small, but okay.
The judge is not elected, but...
What is he worried about happening?
Well, when public opinion is against something, it causes conflicts.
Yeah. What does he think could happen?
That should be avoided.
And what does he think could happen?
The president could not enforce it.
Yes. That's what he's worried about. Yes. We'll say it, but they might not do it.
Do you all remember what happened after the Supreme Court overturned Plessy versus Ferguson and decided in Brown versus Board of Education that separate could not be equal? What happened then in the schools in states like Alabama? Any of you know?
Private schools were created.
They created some private schools to do what? Keep them separate?
Yes. And by the way, does anybody know what happened in Little Rock where the judge said, go ahead. Little Rock High School in September in 1957, you go put some of those black children in that white class. What, do you know the governor? Have you ever heard his name?
Who was the governor back then in Arkansas, in Little Rock? Do you remember?
Governor Falbus was his name. See, I can remember that. I was growing up then. I was alive.
He stood at the schoolhouse door.
Yeah. And he said no.
And said, you can't come in here, you're not white.
Right.
Imagine.
And what happened next?
Do you recall what happened?
He called in the National Guard to ensure that the blacks would not be admitted.
Right. And then what happened?
And then President Eisenhower recalled the National Guard and then sent in the troops from the 101st Airborne Division to escort the African Americans to school.
Yeah.
Yes.
Precisely. Did the president have to do what he did?
Yes, he did.
Why?
Because the Supreme Court ruled that that was the law.
Well,
what does the president say on January 20th when he raises his hand?
Dwight D. Eisenhower, do solemnly swear. I, Dwight D. Eisenhower, do solemnly swear that you will faithfully execute the office of President of the United States. That I will faithfully execute the office of the President of the United States. And will, to the best of your ability. And will, to the best of my ability. Preserve, protect, and defend the Constitution of the United States. Preserve, protect, and defend the Constitution of the United States. So help you God. So help me God.
Let's say you're the attorney for General Eisenhower. You're the White House counsel. Big deal. You have an office right next to it. And you know what's going on. You hear on the radio, you get phone calls of the governor has called the troops out, and you go into President Eisenhower, and you say, excuse me, Mr. President, I know you're busy, but I've got to tell you something. And I'm the president. Yeah, I'm busy. What do you got?
It's your duty to protect the constitutional rights of these African American citizens, so you must take action.
Well, I'll give a speech next week on it.
We have to take immediate action? Because it is your duty to...
The minute I see something wrong, I have to send the army in? I mean, I used to be a general, and I know how to do that kind of thing if I have to. But do we have there's a lot of people violating a lot of laws here. I'm going to send the army in every time you come rushing into my office bothering me?
Well, the Supreme Court just declared that schools must be integrated, so you have to protect their decision and support their decision.
But I guess the Supreme Court can't order the president to send troops, can it?
No, it cannot. But however, since it is the president's duty to protect and preserve the Constitution.
Was there a special reason here? Do we usually use the Army to enforce our laws in this country?
No, we do not.
What's the special reason for you coming charging in my office telling me I have to use the Army?
Well, the Army's purpose is to protect and preserve the Constitution as well.
But that's true in any time the laws are being violated. What's different about this?
You have to protect the individual rights of these individuals.
Why?
Because by discriminating against these the purpose of the government is to protect the rights of the individuals, and by discriminating against them, you are inherently not protecting their rights.
Do you know what happened when the governor sent troops to prevent these small black girls and small black boys from going to this school? What happened? Did the rest of the world know about it? I was in England in school at the time. It was on the front page of every single newspaper in the world. In the world. And this was an opportunity and a necessity to show that we enforce our laws where people are being hurt. And if you have a governor take the extreme step of calling in his own army, an extreme step, almost unheard of, then you are violating your duty, Mr. President. The oath you took when you took this office to preserve, protect, and defend the Constitution, and if you don't do it now, every other school in the country that's segregated is going to do this same thing, and your laws are shambles, and your Constitution's a shambles, and your presidency is in danger. That's the kind of thing to say.
Brown versus Board of Education was one of the most important cases that this court ever decided. It was really crucial in determining what it was that our Constitution means and what our country stands for.
We're 9 teenagers. We thought this was a place that would accept us, that would belong. We saw it as a building that offered opportunity and options for us. And you know what? 50 years later, I think we were right. Thank you, and God bless.